Hi, welcome to This Week in Property. I'm Jayashree Kurup, I'm editor MBTV. We've got a really high-profile panel sitting with us. The three cases we're referring to is the Supreme Court quashes one-sided clauses in builder-buyer agreement. The Supreme Court orders for refund even when the builder has offered possession. And Supreme Court upholds 100 home buyer limit for IBC proceedings. Discussing the ins and outs of the legal quagmire that we are in is Abhilash Pillai, his partner Cyril Amarchand Mangaldas. There's Aditya Parolia, his partner PSP Legal, and Aishwarya Sinha, he's an advocate with the Supreme Court.
I think it's a journey which is yet to be completed, and I think more than courts, government intervention is required. Courts are intervening, but on the ground reality, even Supreme Court is the highest court of the country. Unless the authorities on the low level and on a district level starts acting, every time not everyone has the means to approach directly to Supreme Court. And it's a long journey from, if you start from the lowest forum to Supreme Court, it takes time, and not everyone has that means also to pay the lawyers and spend that money.
The Supreme Court picked up the IREO Greystech matter and evaluated the entire issue and held that one-sided clause agreements are unfair trade practice, and that is something which has to be dealt with an iron hand. This is a very significant judgment. This is just not restricted to the home buyers. This judgment is coming under the provisions of the Consumer Protection Act. So this precedent will even extend to other agreements in other service sectors where one-sided clauses have been proposed or which is being proposed. Right. The second judgment, which is of 3 days back of 19 Jan, is from the three-bench judge of the Supreme Court, upholding the amendments which has been carried out to the IBC. Supreme Court has reiterated that IBC is one of the significant major economic reforms or a measure which has been brought into our country, and that is going to be here, that is going to stay here. So, and in that context, Supreme Court also emphasized that the home buyers will continue to be the financial creditors, no doubt about it. They will have the ability to enforce the provisions of IBC alongside RERA and Consumer Protection Act and the other civil remedies against a developer.
I think these two cases, especially these two judgments which were passed this month, I think we have taken a little bit of a step back. Okay. Let's start with the IREO judgment. Yeah. IREO judgment, earlier practicing in Supreme Court, a Consumer Protection Act was considered as a beneficial piece of legislation. So it was an addition to the existing remedies one always had. Then RERA came about. But the IREO judgment, in fact, it sort of restricts that. So it restricts the available remedy. You can either approach the Consumer Protection Act or the RERA. So that distinction has been drawn. So I would look at it in a way that one of my remedies is sort of curbed.
IBC?
That is that one. And when I go through this recent judgment wherein the amendment was upheld, so initially 58F, which was brought about, was because of Supreme Court indulgence. Now that happened because of the JP case. Now this amendment, it sort of curbs the right of an individual to approach a particular remedy which was available under law, because it casts a certain restriction to initiate that process. Firstly,
are you talking about the IBC?
Yes, I'm talking about the IBC, the recent judgment, the IBC judgment where the amendment was upheld.
Yeah.
So
in the judgment, before you go on, yes. In the judgment, the judge had said that this is an act, an order by the executive. The executive has gone into the ins and outs of the case, and there is some reason why it was there was a 100 buyer limit, and they are saying that we don't want to challenge the executive. Now that this is why I thought the phrasing was very significant, and I wanted your comment on that.
So the justification, I have gone through the judgment, and justification is they're trying to balance it out. So the executive realized that it was lacking at the time of JP case also.
Right.
So because there was a complete vacuum in the code itself regarding the real estate allotee.
Yeah.
So the executive was lacking and the executive realized, and that is why this amendment was brought about pursuant to Supreme Court litigation
Right.
in the JP case. And that is how those JP
Where
case,
the consumer was made a
financial creditor. That
financial
amendment was specifically brought about.
Yeah.
So the courts can interfere with the executive if they find some lacking, and the courts can nudge the executive also if they want to bring about some change.
Sure.
So,
We'll come back
yeah,
to that.
yeah.
Aditya, you wanted to say something.
Adding on to what Aishwarya said, I agree with him on these two judgments has been such a setback for the home buyers. See, there have been total 5 judgments this month. Like, I know that because 4 of them were some way or the other, we were there in those judgments, and I see a lack of uniformity in Supreme Court decisions also.
Okay.
Geetu Gidwani Verma was one of the most landmark judgment where unfair trade agreements and everything was set it up, and they used RERA parameter to give delayed compensation or refund. We have seen a shift from there, which was considered to be one of the most consumer friendly judgments.
Yeah.
Now, in Abhishek Khanna judgment, which is IRO judgment, if you go through it, there are certain exemptions which have been given to the builder based on the COVID situations, but it has to be kept in mind that these situations were not there when these bookings were made. These situations are prevalent just for last 11 months, but a poor consumer has paid this money for last 7 to 8 years, and despite that, the builder is actually troubling him a lot. Now, there are other judgments of next gen, and which is quite favorable for the consumers, which has come whereby they said, no, you have to give refund even if you are ready with possession and everything. I think those are the judgments which I see much more consumer friendly, and one that should be followed. Yeah. Coming on to the IBC part, our main set of argument was that, and which court has also appreciated and said that you should go to RERA and ask them to enforce their rights to know how many allottees are there.
Right.
Actually, our population is around 150 crores today. To find out 100 allottees from that one particular unit, it's next to impossible.
Okay.
There is no information which is available in the public domain.
Yeah.
And even if I find 100 buyers, there is no info. Getting them under one umbrella is a huge task. Not everybody goes with the same mindset.
Okay, is this an effort to nudge the consumer towards RERA and consumer redressal? Is it let me while you both of you represent home buyers, and there is a lot of home buyer influence. Home buyers have become a very powerful entity, very powerful entities. One of the things that has been noticed is that there are 2 sets of home buyers, and today we're grappling with that. And this is the legacy we carry. There is the end use consumer who wants that house. There is a lot of buyers. This is not a value judgment, but they are the ones who did not want the house, who wanted to benefit from the appreciation. Nothing wrong in it. Free market economy, you can do that. But the point is that today, when the markets are down and markets have not risen, last 8 years, the property prices have been depressed. Today, the law that came that allowed you, the MCLR +1, the amount you get out of that is more than what you get from the house. It is opportunistic. If the markets had been good, maybe the volume of individual consumers who would have gone to the IBC would have been far less. This is a hypothesis I'm placing on the table. Abhilash, what do you think?
See, I don't think there is any disagreement between 3 of us that the home buyers' rights should be protected.
Yes.
If their rights are protected, then only the real estate and industry will grow and improve, and it will give the returns back to the home buyers.
Yeah.
So it is very clear that their rights have to be protected. So far as the amendment is concerned,
yeah,
there are 2 aspects which we should see.
Yeah.
The amendment is that there is a second proviso which has been added to Section 7(1) of the IBC. Yeah. Which talks about the rights of a financial creditor, which is a home buyer, to initiate restructuring process, insolvency proceedings against a developer, right? Which is a corporate debtor. Now, There are two thresholds which you need to meet to initiate that process. One is either you need to have 100 allottees or a 10% of the total allottees, whichever is less.
Yeah.
This is what the new amendment is talking about. What Aditya was referring to is a very logistical difficulty which he was pointing out, which is a very valid one. That I'm sitting in an NCR, and a person who is in Bangalore or Hyderabad would have booked a unit in Gurgaon. I don't know the person who is sitting in Hyderabad or Bangalore to coordinate with him and make a group of allottees to initiate this process. That's what he is about. Yes, that's a very practical challenge which the home buyers will face. But eventually, this is going to get sorted out through a process. I'll tell you why. Because every developer is supposed to submit a quarterly report to RERA. That is a statutory requirement under the legislation. In the data which you are going to give, some of the states have come up with the rules saying that you will also submit a list of allottees along with that quarterly report. One can obtain this list of allottees through RTI from the respective RERA and have that information before initiating any such process. Secondly, IBC is not a recovery mechanism. IBC is a restructuring mechanism. The entire law has been brought into in this country because the SARFAESI and the RRDB Act have failed in protecting the interest of the public money which goes into the hands of these debtors, and the delay in recovering this money. And there is no effective mechanism to restructure these debtors and continue with the industrialization of our country. So the significant step is that this is an economic measure for restructuring of a debtor, not a recovery. So when we look at it from a home buyer's interest, let's look at it from a home buyer's interest. If one person is allowed to initiate an IBC proceedings against a defaulting developer who is a corporate debtor, that will actually scuttle the efforts and interest of the other 99 home buyers. I would see this amendment as a most beneficial thing for the home buyers, because it protects the interest of the home buyers as a whole. It is not taking away their rights. It is actually just putting the mechanism in a structured way. That okay, so if you look at the Manish Kumar judgment, where the Supreme Court upheld this IBC amendment, Supreme Court has given a statistical data about the cases which have been filed by the home buyers before various NCLT. And we have seen Aditya, he is a leading practitioner on that. He will be able to tell me that. We have seen applications getting filed one after another. So what is happening? The entire adjudication process is getting delayed, because every application will have to be heard and adjudicated. You cannot say that okay, one application has been heard and because the facts scenario would be different. So this amendment will also ensure that a consolidated restructuring process has been initiated, and it can be achieved in a time-bound manner. Because in the IBC, the adjudicating officer has to admit the petition within 14 days from the date of filing. So every time when you file an application, the date can actually go into chaos. So that's something which, if the group is going, the home buyers, and initiating this process, that will actually expedite the process and it will protect their rights, right? That is, we should look at it from that perspective.
Okay, Aditya, you wanted to say something.
See, the underlying issue is something which I think the government has missed, not the courts, or none of us have missed that part also. Why IBC was being used by home buyers was because it was effective, it was fast, and it was generating results. It was just not a
It was
degree.
not generating results. No, Aditya.
No,
IBC
was.
no, 1 minute.
No.
IBC was not generating results. It was individual developers negotiating offline with for fear of the IBC, which was yielding results.
Yes, the fear of the legislation was generating results. RERA and Consumer Protection Act has failed to do that. RERA
IBC was being used as a blackmail tool in many cases.
The Consumer Protection Act is still or was taking a huge amount of time in getting the issues addressed. In RERA, in Haryana, if you see,
So did
for
the
last 2 years,
the IBC. None of the, this is no easy solution. We are facing a 12-year legacy of problems. And if the solution lies in two people going and negotiating offline, is that a solution?
No, but tell me, you want a holistic solution, and that should be driven from the consumers. That is something which a government or the state authority should drive.
Yes, I agree with your point.
And I understand that these consumers, see, if you take an individual who has invested all his money, he wants his money back fast. He wants to invest in his children.
He wanted his money back fast, always. But the system has to take over, and you cannot play the system to not allow the system to function.
But why was being IBC favored is because system failed. So home buyers will not left.
It's not that the IBC was effective. I'm sorry.
No,
I would still say that the IBC.
Jayashree, let me. If we see IBC now as it is today, it is actually very effective if you want to take somebody into restructuring model. Now with this reverse insolvency coming in, we discussed it last time that reverse insolvency, but it's a beautiful process. If your entire society gets together and the project has been abandoned, use reverse insolvency, and at least if you're not getting your money back,
coming together anyway. No, there in reverse insolvency, you're coming together anyway. In this particular case, you're not being kept away from it. They're only saying come in as a group. And I accept what you're saying, that it is difficult to find those people. The mechanism
not about finding also. No, Jayashree, it is not about finding. It is about failure of two main legislations in providing grievous redressal to that particular individual. That was the reason why people were looking for IBC.
Aishwarya.
I'd like to add to Aditya.
Yeah.
So see, there are a lot of other things also which must be kept in mind before taking a view on this. So earlier the remedy available before the IBC, let's go before the IBC.
Yeah.
The only remedy available was to go to consumer courts.
Yeah.
And consumer courts, the explanation offered by judges for longer dates given to us, as Aditya would know, that eventually you will be compensated with the interest percentage.
Yes.
That was the explanation, because we understand that the benches are overburdened, and we used to get sometimes 6 months, 8 months, sometimes over a year date, because the benches were clogged. And this I'm talking about the topmost consumer forum, that's the National Commission.
Yeah.
Right.
Yeah.
Now, what happened? Now, as lawyers, as Aditya would also face this problem, we were forced to answer these questions to our clients as to why this is taking 4 years, 5 years, sometimes more than that.
Sure.
So that is something we had to face on a daily basis, and we did not have convincing answers. Till date, we don't have convincing answers on that.
And that's when the RERA was brought in.
RERA was brought in, but the RERA, the rules were given, the power to frame rules were given to respective states.
Yeah.
The RERA, if you read the act is very stern, and it casts the responsibility both on the buyer as well as the builder. And I'm with you on that.
Yes.
But it gave the power to respective states to dilute the rules.
Yeah.
So the effectiveness and the implementation, my opinion, has been diluted.
In how many states would you say it is diluted to an extent?
Also, if you look at real estate, in how many other states apart from Delhi NCR have you seen this problem? I'm not saying that the real estate sector in the rest of the country is going fine, but the lowest of lows has been seen in Delhi NCR. So it's it's understandable. And just to add to that, the IBC, the only remedy and only the blessing was that it is time bound. And that was the main draw of the buyer. And I must also tell you
results that IBC has given. How many IBC cases have actually gone through to resolution and given you the money back? It is actually offline transactions that have yielded results, not the IBC.
So Jayashree, IBC came about only in 2018.
But the volume of cases has been very high.
Because the consumers were not getting the effective remedy which they thought they deserved. And
they haven't got it here. My contention is that they haven't got it here.
And I will tell you that even after this amendment, 100 threshold and other things, the remedy whether they will actually get the remedy, because after all, they are still unsecured creditors.
Sure.
So because they are not getting a remedy, that naturally should not be presumed to not initiate that particular legal redress.
Okay. Now I'm going to actually go to
Just to add on to that.
Aditya, this is a forum where people can ask their queries. So I would like you guys to also listen to the queries and then carry on the conversation. We've put our opening arguments out there, right? There is Ravi Divakar who says, how does IBC judgment change the status of home buyers vis-a-vis financial creditors like banks? Just hang on to the queries and then we can pick them up. Then there is, how can a buyer bring 100 buyers with the same cause of action to file an NCLT case? How can they bring the issue that both of you raised? There's Akanksha Thakur who says, what does the IBC judgment say on the data of consumers to make 100 buyer quorum? How can a single buyer do it? The issues are what you've raised, but buyers are raising it. I thought it's important to raise them. Can buyers with different cause of action join to form this 10% threshold limit to file an NCLT case? And section 32, sorry, has been discussed in this case as well. How does it change the position for new bidder in an NCLT proceedings? Let's discuss these, then I'll pick up the other queries.
See, I'll tell you, it doesn't change your status. You're still a financial creditor. That remains the same. A lot has been discussed in this judgment on how one will muster this number 10% or 100. There are certain silver linings for home buyers which have been explained in quite detail in this judgment. One of them being that 1/10 strength, when it will be factored into, it will be factored into as per the number of allottees and not as per the number of units in the project. So it means if you have 1,000 units, you don't need 100 buyers, but if 400 have been sold, you just need 40 buyers. Okay. Further on the default part.
Before you say that, are you able to know how many houses have been?
I'll come to that on the second part.
Yeah.
Secondly, on the default and the cause of action issue, another good explanation which has been given in this judgment is, if there are 100 buyers and default is only for a select few, but default is more than 1 crore and other people are just backing it up, still your petition will be successful. So if I say, in case of home buyers, 80 people have not got, their date of possession has not expired. Yeah. But for 20 people, date of possession has expired, and together they take the company to file a section 7. This petition, if it crosses the threshold of 100 and 1 crore in rupee, will be successful. That will be valid. Now, the most important question is how to muster this 100 number. That is a problematic thing. There is no data. Yes. Even if we file an RTI today, no RERA has that data. It is not there.
Yeah.
And again, how it can be possibly achieved that RERA gives you a data, then will you call up everyone that, okay, sir, I'm going to file a petition. Will you able to join? Then to explain them IBC. It's very difficult. See, I'll tell you.
Yeah. You're doing that. Even today, you're doing that. If 10 people, 3 people come to you, you do find there are WhatsApp groups, there are other groups. You are calling people. And you are doing it. Otherwise, how are you getting the required numbers to fight these cases? You are doing it.
No, they are.
The law does not.
It is very difficult, Jayashree. See,
I agree with you.
We are dealing with 7 groups which are 100 in number.
That's right.
Okay.
That's right.
Formation of each group by these home buyers who got behind each and every one, and then they mustered the number. Then they came to us. They informed us that it took them 6 to 8 months.
Yes,
and
I agree.
Still, it is very difficult for them. And in meanwhile, a lot of things get. Suppose builder has got OC, but the construction is shoddy. Just the builder gets to know that, okay, these 5 are the core people who are forming the group. He will settle those 5. All these are practical things.
See, there are 3 laws. Today, there are 3 laws. The 3 important laws. If construction is shoddy, if there is structural flaws, you have to go to RERA. It is a 5-year zero defect liability, and RERA is
something different, Jayashree. I'm saying that. Suppose somebody gets to know that these 5 people are mustering 100 numbers.
Yeah.
It is very easy for them to settle those 5, and we come back to your argument, then it becomes an individualistic thing. that
Yes.
these 5 people are being settled and rest 95 are left.
Yes.
So if we see, if you want a restructure of the entire project, if you want to actually benefit the buyers, we were expecting this number to come down, and there are certain restrictions which we wanted in place. Though it has not been done, 100 to muster 100 numbers, there is no information. It is still very difficult. It will not be possible for a huge number of projects.
100 is
Plus,
only if
if
you have
you
1,000 apartments. No,
Yes.
those very large apartments. If
in
you have
Delhi
100
NCR, most of them,
apartments, only 10.
but Jayashree, more in Delhi NCR or Bangalore or metro cities, that is the number of apartments which are being sold.
No, in
If you
every
see
place.
projects are
Yeah, Abhilash.
So just to add to what Aditya said, see, there was a study in 2019, if I'm not wrong. This is just after the JP judgment.
Yeah.
And before the Amrapali matter was going on, and before the Unitech judgment coming out, that whether is it RERA or IBC effective in terms of addressing the issues of the home buyers, and are they happy with IBC or RERA?
Yeah.
There are the study says that the home buyer who has approached RERA got his order in his hand in 12 to 16 months, whereas who has initiated or who is part of the IBC proceedings is still fighting for his rights and the apartment.
Right.
We will come to the issue separately, that whether the RERA orders can be enforced efficiently, whether that mechanism is there or not. That yes, that problem is still to be resolved. Those are the teething issues which will get resolved, and the home buyers will be able to get their rights enforced through RERA, and it effectively and eventually it is going to be the RERA who is going to hand over these kind of rights and ensure the rights of the home buyers in this country. It is not going to be the NCLT through the IBC mechanism.
Because wherever we've had a regulator, whether it is TRAI, IRDA, SEBI, and so on, allowing that regulator did not function from day one. The process, this regulator was brought in because the system had failed. And the regulator needs to fix a lot of things before it happens. But in this case, because of before the regulator can get going, what is happening? And the reason why I'm forcefully arguing this point is because there are cases that have gone up to a certain point in RERA. The RERA was going to award to the consumers to build and finish off, but 3 consumers went to IBC, and the RERA has to perforce give up. And even in that Rohinton Nariman judgment, the Pioneer Urban judgment, because the IBC was a later law, therefore the IBC holds precedence. It's not that the RERA is a lesser law, but the point is that if you don't let a regulator function, we will have the problems for all times to come. It will never find solution except for individuals.
Jayashree,
and it is also equally for the home buyers. Sorry, I'll just make a point. It is also equally for the home buyers to ensure that they don't scuttle this entire process. If there are 100 home buyers and someone is trying to settle 5 matters, the home buyers will have to think of the others' interest also. Yes. Because it is not only your unit you are going to get in that entire project.
Yes.
It is a multi-story society. It is a group housing, or it's an apartment which is getting formed. And you're not going to stay only there in that unit, right? So it is a collective mechanism. It is a collective interest. So that is where the home buyers will also have to be mindful of the fact that they don't fall into the traps or the influence of the interested parties. So right. that is also something which they have to keep in mind.
Yeah, Aishwarya, you wanted to say something.
Yeah, one thing I wanted to say as regards joining 100 people. Yeah. I am on the very primary aspect as to why one person has to join causes with 99 others. Everybody has invested or bought a place for some motive. It could be an end use, it could be for appreciation, it could be for post-retirement, it could be for family, it could be for whatever reasons.
And everything is legitimate.
Everything is legitimate. I'm in no position, we are all item, we are in no position to distinguish everybody's interest here.
Right.
So let's assume a situation, somebody has invested say all these projects, especially Delhi NCR, these big JP, Unitech, Amrapali, if we talk about, they're around 2008, 2010 onwards, right?
Yeah.
So this IBC never existed till 2018.
Right.
Right. So these projects were to be given as early as 2010, 12, 13, 14. Nothing happened. People went to Consumer Protection Act and that was going on. And up till 2017, 18, in fact, a lot of people got money back also after securing a judgment from, say, Consumer Protection Act and then going in appeal to Supreme Court. A lot of people have got judgments. I have got a lot of judgments in favor of a lot of my clients. Now, that was an individual case. And in fact, the Consumer Protection Act factors in for an individual as well as a large group. There's a special classification the Act provides. Now, 58F was brought about. It allowed an individual to go ahead.
Yeah.
Now, every individual will have a certain kind of need or a certain kind of grievance.
Yeah.
And when he is asked to bring in 99 more people who may not have the similar sort of urgency of funds or the urgency of flat to join causes there,
Yeah.
and getting that many people, it's not only a logistical nightmare, it is very difficult for people to actually agree with the needs of the other, because people have to join with my cause after all. Whether I am the difficulty which I am facing or the urgency which I have, the 99 other people should also have a similar type of urgency. So it's
Isn't the cost to get the project completed and get
We
your
can't be the judge of that. We can't be the judge of that, Jayashree. Somebody needs the money.
if the project is delayed,
back.
see, somebody, I have had instances, people have had having medical emergencies.
Yes.
That's the most common thing and the most legitimate thing. And
But
people
did
were promised
the
that
IBC reward them? Did the IBC give them their money back?
IBC is not the remedy. IBC is not a recovery action.
Consumer Protection Act. It's not the IBC. You're
now,
going to the wrong
coming
court.
to the Consumer Protection Act also, how that has been diluted and how that has become an ineffective tool according to me now. I will be coming to that also. But asking us say if I have a grievance and my grievance is emanating out of whatever my personal issues, my need of funds, etc., etc. If I am asked to seek 99 more people to think similarly like me, so
But
that
if
is
the IBC, will the IBC give? I agree with. Let's go with the
IBC
argument. Let's go with the
if-
argument that you raised. Somebody has a medical emergency, wants the money back. I agree. There are a lot of people who have this. But
yes.
if you as a consumer go to the IBC, is the IBC empowered to give your money back?
But it
IBC
makes people
Make
settle.
the
No, no.
entire thing solvent.
Sorry, Aishwarya, but
Yeah, go ahead.
it forces corporate debtor to settle with you, and that is one of the main. No,
That's not then.
That
no,
is
no,
an arm twisting.
that
That's
is
an arm twisting remedy. That is not.
the objectives of the IBC. If you read the parliamentary legislature, the arguments and the assembly debates, it is within the objectives of the IBC that is why the power has been given to banks to go and invoke Section 7 so that people can come and pay back your dues. That was main objective. It was one of the main objectives.
Just to add to that, Jayashree, in fact, let's look at operational creditors and financial creditors apart from real estate allottees also.
Yeah.
Yes.
There are so many contractual obligations every company has.
Yes.
So every company, and for them, these thresholds are not there.
Right.
So for every company, if there's a breach of some dues which are admitted on the part of the corporate debtor,
Yeah.
everybody is approaching the insolvency tribunal and initiating insolvency in the hope for a settlement. And when I say settlement, it may not be read as arm twisting, but it should be also considered as urgent relief to that concerned individual.
We assume that there are 100 buyers. There are 100 buyers, 10 vendors, 3 bankers. If two buyers go to the IBC, the company will. 1 minute. The company will settle out of court. If 20 more go, those 20 need not necessarily be settled because there is not enough money on the table and work has to go on. Now, when the vendor goes to the IBC, if the vendor also goes because I want to get my settlement done, then the very purpose of the law is defeated.
No, that is the purpose of the law. No, that's the very purpose. No, that is the purpose of the law.
No.
That is the very no. It is just the one judgment which says that it is not a recovery mechanism, but if you read the statement and objective, which is also in this judgment, it says that it is one of the objectives.
To settle
Yes,
with
to settle the dues. Yes, it
no,
is there.
no.
If you
No,
read,
no, that is not the objective.
That is
That is not the objective of
if you
IBC.
read
That is
the
not the objective of
parliamentary debate,
The
the act was passed, it is said that one of the main objectives of this act is the settlement of the dues also.
settlement of the dues, not
Objective
by
objective is to
no, and now
restructure the corporate
just
debtor.
last point, Abhilash. Just tell me, Jayashree, why this onus has been put on the only on the home buyers that you should look for the completion of the project and not come in such IBC? Why
They
not
do
the
say
banks?
that. You can go to the
Why
Consumer
not the
Protection
banks?
Act. You can
Are banks not concerned that home buyers should get the money?
You can
Banks are
go
the
to the Consumer Protection Act, which was for the consumers. Why have you moved away from that? One minute. Why have you moved
No,
away
what
from
is the banks?
It is-
What
it
is
is
the what are the
given
banks
the
trying to
same
achieve?
in a particular
Banks
time
are also
period.
trying to achieve the completion of the project, because if the project is not completed, they will not be able to sell the entire units and recover their money. So the ultimate objective is to complete the project, restructure the corporate debtor, and the put the business back on track. It is very clear from the objective clause of the act. And if you look at the parliamentary debates and the parliamentary committee reports, it is very clear that IBC is not a recovery mechanism. It is to restructure the corporate debtor, throw out the previous management who was not able to fulfill or run the company properly, and bring in a new management who is capable of handling and doing that business. This is the sole objective, if I could put it in one sentence.
Okay, I want to actually raise some more issues that the consumers have raised. Lalit Sharma says, can home buyers file a complaint in RERA for refund, as NCLT is not going to accept a single buyer case? That he can, right? That's the answer is yes.
Yes.
Yes. Parul Tiwari, who has said buyers have a problem that litigations take a lot of time even after orders from NCDRC. Can't there be a solid system which gives respite at one place? RERA was made for it, but its remedies don't work. NCDRC and Supreme Court give better judgments than RERA. Now here, I think one of the important things that I want you guys to actually debate is, why are you moving away from the consumer forum? Because you don't get your dates. And why don't you get dates? Because there are so many individual complaints. If you allow the IBC also to take individual complaints in the hope that they will be settled offline, won't you clog the IBC system with individual complaints?
Actually, you do two things with Consumer Protection Act and RERA. Give them more teeth or content powers.
Exactly.
Make shorter dates. I don't think anybody will require IBC. Okay?
Exactly. And that's where we should
So
fight.
that was my opening statement when I said the state authorities have to go to the underlying problem and resolve that. That is the main issue which is lying here. Also to add, which you were saying, that is RERA a good restructuring and a completion act? No.
Not RERA.
If you believe that a good completion of the project is to be achieved by somebody, which is also in RERA, I think I'll personally take reverse insolvency mode, because it ring fences the home buyers as opposed to the banks and all, which is not provided in the RERA.
But there you need a certain number of buyers.
Sorry, ma'am. Sorry.
But there you need a certain number of buyers. Two buyers can't become the reverse insolvency.
You need the same. I think you need certain numbers in RERA also to ask to take over the project.
RERA has the ability to go out and source that information of who the buyers are, whereas the other courts are taking way longer. And
the two-third approval under Section 50 of RERA is where there is a voluntary transfer which is happening. But RERA has actually an unlimited power to actually transfer the project to a new developer if the project is not being developed. But for that, they cannot do that action suo motu, right? That's something which has to be initiated by the home buyers. Yeah. And one person cannot change the world. That is where even in the consumer forum you have the class action provision, where people can come together and actually initiate a group action, a class action. And those actions will actually yield more result than an individual fight which is happening.
I'm going to give it to Aishwarya. He has been trying to say something. I'm sorry, Aishwarya, you haven't been given the chance to say something.
I'm going to be muted.
No, please don't do that. This is a discussion. I'd like everybody to be part of it. Yeah, Aishwarya.
So now let's refer to, I'm just adding to what Aditya was saying about the Consumer Protection. Now, the Consumer Protection Act, a new act has recently been introduced.
Yeah.
Now, we all knew the premier forum under the Consumer Act was the National Consumer Forum.
Yeah.
And all these consumer forums have been differentiated on the basis of the pecuniary value.
Yeah.
So depending on the value of the flat, you either go to the district, state, or the national commission.
Yeah.
Now it is broadly for reference purposes, every flat is mostly around under 1 CR.
Yeah.
Generally, let's assume that. So now earlier, what remedy a consumer had, an individual consumer had, was to approach the National Consumer Forum, which itself was lacking infrastructure and was continuously taking a long time.
Yeah.
3 years, 4 years.
Yeah.
Now, what happens is the new act introduces new pecuniary value to each of the basically deciding as to where one can approach and which forum one can approach.
Yeah.
So district commission is, I'm sorry to say, the administration and the functioning is pathetic, to say the least, because there is hardly any infrastructure, there is hardly enough members. So now the district commission has been empowered to hear matters up till the value of 1 crore.
Yeah.
So the National Commission, which was the premier forum under the Consumer Act, which was functioning in such a slow manner, now that responsibility has been delegated to the district commission. Yeah. So now the pecuniary value of approaching different consumer forum are as follows. A flat value up till 1 crore goes to district commission.
Yeah.
A flat value between 1 to 10 crores goes to state commission, and only 10 crore and above goes to national commission. So that is further demotivating for the buyer, because earlier what we used to think that going to the National Consumer Forum and the only appellate remedy was the Supreme Court. But now the district commission, followed by state commission, followed by national commission, up till Supreme Court. And we all practicing lawyers know how our district commission are and how under-equipped they are.
In fact, this is I think the purpose of this show was this. I wanted to see where the problems are, and this particular show is going as a recommendation to the ministry, to the higher authorities.
We've been clipped both ways, to say the least.
Yes, absolutely. And I agree.
So the Consumer Forum, the act has been changed.
Yeah.
And I have been relegated to the district commission because an individual average flat buyer could go there. Yeah. So the National Commission itself used to take 4-5 years. Now we have district, state, national, and Supreme Court for an average consumer spending at least 3 years in a particular forum.
Sure.
I'm giving ballpark figures.
Fair enough.
And IBC, when I had an individual person who could go, and I must tell you, the individual knows that upon completion of the COC, he falls low in the pecking order. He's an unsecured creditor, so he is very well aware that he may get peanuts eventually for his dollar.
Yeah.
So, but then he had this hope that A, it could be time bound. B, the builder would give him an audience. C, that there is a possibility of some settlement.
Yes.
Yeah.
So those three things goes.
Point taken. I before both of you say something, I want to raise a point that has the IBC been time bound? The IBC has not been time bound. We have not seen the pace at which the resolution should happen after it's given to an IRP. I've heard from hundreds of thousands of consumers that the IRP slows things down. Many IRPs have slowed things down. Has it happened?
I think things have changed and will change after this Umang Realty judgment, which came last year in January, and Babita Gupta, whereby the reverse insolvency for home buyers was introduced. I'm again and again emphasizing on this because it is a shift from the normal IBC, which has been adopted for the home buyers.
Sure.
I think that's a time-bound process. I personally have seen in both the projects that completion is being achieved within a period of 6 to 9 months, and they'll soon be handed over the projects.
But it's not an individual solution; it's a group solution. So why?
Yes. Now coming, just adding to what Aishwarya said. See, I still find Consumer Protection Act to be the one of the best remedies if we compare all. If you just make it time bound as mentioned in the Act, the Act says 180 days. If I'm not wrong, if you make it 180 days, it is the most effective remedy by the home buyers. Just to give some heads up to your observers, consumers also. I think the president who is there in Delhi State Commission and the nation have made an attempt to do that with this new act.
Okay.
They are
Okay.
trying their best, but government has to appoint new members and give them more strength so that they can meet this timeline. You cannot expect these people to hear hundreds of cases in a day. That's impossible.
Right. Agree. Abhilash, a quick answer from you, and then I want to pick up some more queries. Yeah.
I think we should distinguish these matters into two parts. The matters which are going to be dealt by the Consumer Forum or RERA or the IBC are the past defaulted projects, right?
Yeah.
The new projects are under the scanner of RERA itself.
Yes.
So the collection of the money and the utilization of the money is being audited by RERA in a time-bound manner. And under the RERA, what they have done is that it is not only the developer who has been made accountable. Every person who is certifying the withdrawal of that money and utilization of that money has been made accountable. So the siphoning of the funds has been blocked there itself. So if that is going to be implemented in a very efficacious way, these projects will see the completion. So going forward, if the home buyers follow the RERA diligently and ensure that the developers are being checked by the RERA in a time-bound manner, these kind of issues will come down. That is the distinction which I would like to make.
The future is sorted. It is the legacy that we that is contentious,
which we need to sort out.
I'm going to pick up some more queries. Divyansh Verma says, I have not heard of any case so far who has got the justice from RERA and is happy. People are first struggling years to get a piece of paper of judgment from RERA and struggling more years to get the actual execution of it. Now, we have, when we started the year, we spoke to a large number of RERA, UP RERA, Karnataka RERA, Maharera, and we did speak to all these RERA authorities. One of the things that they all agree that they don't have the execution powers, and they are expecting that there will be a change in some kind of norms so that they can have these powers. But more than that, one of the things that all of them said is that you have to empower the right forum, right, for the right things. And empowering today has to come with RERA, because that is the forum that is most equipped to handle the large number of consumer complaints, right? And there, I believe that is one of the things that we have pushed as one of the recommendations that we have given. There's another query that has come. Will IBC amendment case in Supreme Court also affect buyers' right in consumer forum? Any answers? It will not. Divya Rajni says, have buyers lost their right to approach the NCLT now? Would you like to tell them what exactly their rights are now?
No, they have not lost their right, Jayashree. If they can muster the numbers, 1/10 or 100, whichever is lesser, they can still approach the NCLT.
1/10 of the buyers of that project.
Allotted units.
Allotted units, or 100 buyers, whichever is less. So if you have a smaller project, you have to have 1/10 of the buyers.
Yes.
Of the units that are already sold. So that's the Abhika, I hope you've got your answer. A. Bhatia says, RERA or any entity need to pull all buyers of a project with email IDs. Transparency can lead to a cleaning of the process. Due diligence reports of banks to be available online. What do you say about this? Can you make due diligence reports online? Isn't there a privacy
not
issue?
Not right now. But once the title insurance provisions have been implemented under RERA, this is going to be available, because this is one product which is being developed by the insurance companies now to roll it out. That the title insurance that is going to change a lot of these issues. The title reports will be available. And this title insurance will be available, and that will also ensure that such projects which have the title insurance will have a better credibility. So that's going to the change the scenario here.
Okay. There is one consumer who's rapped me on the knuckles, who says, dear Jayashree, please interrupt discussions at minimum. You're disrupting it too much. But the idea is to disrupt. Unless we have as a moderator, if I don't get all aspects of the case, then you will not get enough responses. And Vimal Goel, I'm sorry that you think I'm disrupting it. The idea is to get more out of the experts. These are some of the finest legal experts we have in the country. If we don't get all aspects of the case, 10 other buyers like you may not get all the aspects of the case, right? And there's A. Bhatia, who says the RP conducted due diligence is also hidden and not visible to home buyers. Is that true in a IBC? When the RP conducts a due diligence, are the buyers party to it?
Well, those reports are provided, or the statistics are provided to the committee of creditors. Home buyers are financial creditors. They form part of the committee of creditors. They have the right to access those reports.
And if
they can ask for it.
If they are being denied, they have remedies available under the Act.
You can ask, see, RP is not the owner running the show now. The COC is running the show. So if a COC will put up something, RP will have to agree with that. Just pass that mandate. You wanted a forensic audit or a normal audit.
Yes.
The reports will be provided to you.
And if they are being deprived of something, the remedies are there in the code itself to approach the concerned tribunal to seek certain documents.
Okay, because he has come back and said the AR and RP do not act on request of home buyers. 2 crore paid to them, no return, zero transparency, 12 months on frauds detected by builder, and RP takes no action or on criminal proceedings.
Now here the issue may be that how many total buyers are there? Whether he's speaking on behalf of himself or he's speaking on behalf of the majority. There could be certain internal things. This is what I could gather as of now.
Okay.
No, actually, if you remember, in Amrapali's case, certain reports which are submitted to the court
Yes.
were shared with the councils.
Yes.
Councils of the home buyers. So that's something which the court will also do it proactively.
Yes, of course.
So you have to approach the court then, right?
Yes, if the RP is not giving them, then obviously they have to knock at the doors of the court.
Okay. And, there are many, Mr. Bhatia, I can't pick up all the queries that you've put in, but he's saying that maximum documents online visible to home buyers, forms CIRP 234 submitted by RP are hidden to creditors. Only transparency can clean the system. Now, there I agree. Transparency has to come, and how that transparency has to come is what the home buyers are battling with. In some cases, the RP is working with the home buyers. Many people have come to us saying that the RPs are not working with the home buyers. Now, Vimal Goel says the courts do not understand the hassles of collecting 100 people and then keeping them together till the end during the long legal battle period. Many people separate after the initial euphoria. Do you find that?
It is not the courts, no. It is the executive to decide on this issue. That's what the court also said.
A ploy sometimes the builders may adopt just to disturb the collective group. Even if I'm able to manage 100 people,
yeah,
as Aditya was earlier mentioning, the builders tend to sort of disrupt those numbers so that I'm not able to breach the threshold. And once again, we go back and fall back.
Yeah.
Even if I muster up 100 people who collectively are willing to join my cause, the builder can selectively, destroy and disturb the 100 group. And suddenly, even if I'm one number down from that, the threshold, the entire thing falls flat.
Jayashree,
Yeah.
Go ahead.
See, I'm saying if you just see the entire discussion and underlying problem,
Yeah.
He's saying was I'm paying taxes. I just wanted a house. Why should his underlying question is that why should I go to court to get my money back?
Yes.
I'm not getting the house. Is there a mechanism in which I can get my hard-earned money back in a very short period, or there should be an automatic medium? That is what the underlying intent of a home buyer is.
Sure.
So
I agree.
if that is not being met, and these are in huge numbers, we have to look that between 1995 till 2020, there's been shift in the economy, entire economy. Okay, people now have money to purchase houses. There's a migration which has taken from smaller towns to bigger towns. People, for the first time, they purchase their houses, so they're heartbroken also. See,
Yeah.
and there are a lot of people who come and cry in front of us. They're not getting they've taken out money from the pension for the children. So that is the underlying problem.
And Ravi Luthra, who says you mentioned Consumer Protection Act, can one invested in commercial project move to consumer courts?
Yes.
Only
if you're an individual, you can move, right?
if
Yes,
you're
but
able
you
to
have to
establish.
explain that it is for your livelihood.
You have to establish the threshold is higher for a commercial project. You will have to explain that it is for your own end use and for your own livelihood.
There's Rajul Srivastava who says, I agree with Mr. Aditya Parolia when we make RERA and consumer courts more powerful, give them more teeth and contempt powers. Currently, RERA is a toothless tiger, and that's where the problem lies. Rajul Srivastava says home buyers are left with no option but to get speedy relief. Consumer courts will take ages now due to the changes in the pecuniary jurisdiction, which is what Aishwarya has mentioned. Just tell me the way to muster 100 buyers. That is Akanksha Thakur. Actually, if you make a provision like this, you also need to figure out how this can be done, right? And
There is a provision, but it has not been adopted by RERA. It has been spoken in the judgment that I think section 11 point something, which says that information should be with RERA.
Yeah.
And unfortunately,
the quarterly report
is not with RERA, and RERA has not enforced it. Neither somebody had taken an initiative to ask RERA to get it initiated. So that is a problematic thing.
But RERA is the authority that is supposed to give this information.
Supposed to.
They are the repository of this information.
Yes.
They will get it. They have the statutory powers to collect it. They have the statutory powers to ask the developer to submit that. Eventually, that is going to happen. And if one of the developers is not following that provision, obviously the home buyer has the right to bring this to the notice of RERA.
Yeah. And in fact, Karnataka RERA has currently issued a very large number of notices to developers who have not put the right information in the quarterly report. We're moving towards that compliance era, but like I said, it's a very new act. The last two questions of the afternoon: what happens if after filing by 100 people during the proceedings, one of them backs out, brings the quorum to less than 10%? What happens in that case? That I think that's what Aishwarya had raised, right?
Case falls flat.
No, it doesn't. I have experienced that in 3 cases.
Yeah.
It doesn't. It is not.
You handle
Courts are quite experienced, and they are tackling this issue.
Of course.
And the legal requirement is
a counter argument can always be made against us that we are not meeting the. I understand courts in their wisdom, they know that what hanky panky may be going on behind the show.
Yeah.
It is definitely obvious because certainly from 100 you are not able to breach that threshold.
Yeah.
But there have been instances that when you have not been able to meet the threshold, the case has been thrown out, and it has happened.
And
in my experience, courts were vigilant enough. They got an understanding. They said, we will not let you withdraw unless it is for everyone. If there is you are offering something, you offer to everyone, or you bring back a plan which will help entire society and entire project. So courts are vigilant enough here. So I have full faith in them.
And the NCLT, the tribunal will also do the test of that fourfold test, which was prescribed by the Supreme Court in Pioneer Urban Judgment 2019. Yeah. So it is not as simple as we speak that okay, someone can initiate the proceedings and the NCLT will initiate insolvency against a developer. So the courts are going to look into the genuinity and the merits of the matter, and then only they will admit these petitions. So it is not an easy task for a home buyer to approach the NCLT.
And the last query, message we've got is an appeal to the three of you as a legal fraternity. Can the lawyer body influence the government to give more powers to RERA, which is the underlying problem? Who in system can change? Please guide. Actually, it has to be the central government. And the central government assures us that they are taking steps. All the RERA say that the central government is appraised of it. In fact, this discussion is going to the central government as a recommendation. And Jayamohan Parmeshwaran says, RERA is another option to make money for officials, it seems. I think that's a disgruntled buyer there. Where to approach to give more powers to RERA? You have to go to the central government and you have to, Ministry of Housing and Urban Affairs, and you have to put it on their website that these are the problems you're facing with RERA. They are the ones who are mandated to change the law or add provisos to it. Thank you so much for all three of you for joining me. It was a contentious issue. It was a very, it's something that a lot of people find very, very taxing. But the answers and the solutions can only come from discussions and debates like this. Thank you for joining this week.
Thanks, Jayashree. Thanks, Aditya. Thanks, Aishwarya.
Thank you, everyone. Thanks, Abhilash. Thanks, Aishwarya.
Thank you. Bye-bye.